Hello, scholars. Professor Takitaki coming to you with a breakdown of a couple of important Supreme Court cases. Really, just one, and then a bunch of history behind it. Because we've seen in the last couple of days a ruling which could pretty fundamentally change a lot of how the American government works. And since we are, in fact, students of American government in this course and throughout the semester, it may be good for us to take a minute and think about what all of this means. Now, the case in question is called Loper Bright Enterprises versus Raimondo. And Raimondo is Gina Raimondo. She's our Secretary of Commerce. Anytime somebody files suit or seeks to find some kind of action against the American government, it's sometimes lodged specifically against the United States, but frequently will go against the person who's in charge of whatever agency they're kind of taking issue with. In this case, is the Secretary of Commerce. So the Supreme Court issued a ruling in that decision, and that has really fundamentally changed a lot for the way our government does business. But to understand that, we need to understand what that case was and what it did. So let's start out with Loper Bright Enterprises. Specifically, the National Marine Fisheries Service created a rule that required the industry, the fishing industry itself, to pay for routine monitoring. And that routine monitoring could cost, several $100s a day. And that was to make sure that the operations of the fisheries were in line with the rules that were set up governing fisheries by something called the Magnuson-Stevens Fishery Conservation and Management Act of 1976. Now, the fisheries themselves questioned whether or not that Magnuson-Stevens Fishery Act authorized the government to charge them for those monitoring programs. So they challenged that case, and they challenged it in the Supreme Court. And so the Supreme Court was required to kind of look at the case and figure out two questions. And the first question is, does the Magnuson-Stevens Fishery Conservation Act of 1976 give the government the authority, specifically the National Marine Fisheries Services, give them the authority to charge that kind of a fee? And that could be a relatively simple decision. They can look at the law, they can look at the act, and they can say, yes, this does give you that authority, or no, it does not. But the second element of this that was looked at by the court is whether or not this challenge should create a situation in which the Supreme Court overturns a case from years ago, and specifically a legal principle called the Chevron Deference. Now, we'll pause here for a moment in the Loper Bright Enterprises, because now we got to figure out, well, what's this Chevron Deference thing? And that's talking about a 1984 Supreme Court case, which was called Chevron v. Natural Resources Defense Council. Okay? So back in 1984, the EPA was trying to figure out how to regulate pollution, or very specifically, how to help states regulate pollution under the Clean Air Act. And what the EPA said was, hey, look, states, you can basically put most types of industrial on-site pollution into kind of a bubble, and therefore individual industrial operations could feasibly change out like their equipment or their practices, so long as the total amount of pollution that was being released didn't go up. Right? And so that kind of granted some latitude to the states, it granted some latitude to the businesses, but it still kept in place the idea of there are going to be standards under this Clean Air Act. And that decision was actually challenged by environmentalists, who found it to be too weak and allowed for too many different types of maybe pollution to get lumped in together, and didn't specifically deal with the kinds of pollution that they were most concerned about. So they challenged the EPA, and through the EPA, specifically the practices of the Chevron Corporation. The Supreme Court found in that case that the EPA was okay, that they had the authority to create that bubble standard, and allow for the idea of a stationary source to mean whole industrial plants. And the precedent that came out of that case had to do with the vagueness of the Clean Air Act. And what the court said in Chevron was that when a law is passed by Congress that is not specific, that the courts have to give leeway to federal agencies who are charged with implementing the law. And that's really, really, really important, because frequently statute law, as it gets passed through Congress, as it moves through and is signed by the president, that kind of law can be very non-specific. Sometimes it'll include terms like, ensuring that this rule is in the public interest, right? Or they'll say, the agencies are authorized to take all reasonable measures required to adhere to these standards and promote the public good. They'll say something very vague and open like that. And that vagueness is frequently deliberate. Congress doesn't have a crystal ball. They can't see whether or not there's going to be a new type of pollutant or a new potential risk or a new technological development just down the line. And so frequently they will write statutes and standards with some ambiguity to them to allow for federal agencies to deal with new things without having to go back to Congress and get an entire new law. So what this also did is it placed the decision on a lot of these issues in the hands of federal agencies. And federal agencies actively employ scientists, economists, field area specialists who contribute to these policies that otherwise further kind of create the bureaucratic reality that comes after statute laws are passed. And so since 1984, this deference that we see in the Chevron case, that if the law is vague, courts will defer to executive agencies, to elements of the federal bureaucracy that have established standards using these experts in order to try to adhere to the letter of the ambiguous letter of the law that's been created by Congress. So that was what Chevron was. Now, let's go back to Loper Bright. Remember, fishermen and fees, and does the National Marine Fisheries Service actually have the authority to create this daily fee for monitoring? Now, this Supreme Court could have come back and simply said, either the Maritime Magnuson-Stevens Fishery Conservation Act does give that authority, or it doesn't. It could have just said yes or no. And if it had said yes, then people keep paying their fee and the monitoring keeps going on. If they'd have said no, that fee could be ruled wrong and that would have to get removed and they'd have to find some other way to pay for that daily monitoring. It also had the ability to make a statement on the Chevron deference. And in this case, by a 6-3 decision in which the conservative members of the court voted in favor and the more liberal members of the court voted in opposition, the Supreme Court not only said that the Marine Magnuson-Stevens Fishery Conservation and Management Act did not give the government the authority to create this monitoring fee, it overturned the Chevron deference. It says Chevron is wrong. And that's huge. Now, it's noteworthy that the decision itself did not undo all of the cases that have already happened in which Chevron was the precedent. Now, there are thousands of those cases. But it opens the door for every single one of those cases to be challenged going forward. And so this, in many ways, could lead to huge changes in the way that our government operates and in the way in which our federal agencies work. Some of the areas where this could impact, the IRS is something that frequently has to determine, kind of based off of the laws that exist, how they're going to implement tax policies. The Treasury Department, the Food and Drug Administration. A lot of times those laws are vague and they talk about public safety or public health. Now, unless the specific issue is mentioned in the statute law, you could have someone coming and saying, hey, FDA, you don't have the power to stop me from selling this food, or regulating this practice in terms of cooking or preparing things, or regulating my circulation of this particular drug or substance. Environmental regulations. The EPA, this is a broad hit to the EPA, and this is one of the places where people expect many legal challenges to come almost immediately, is if the EPA is charged with something like preserving environmental quality, but there isn't a specific law that says these specific substances in these amount are potentially illegal or are illegal, the EPA might not have the authority to tell a company, hey, you can't dump that. The company could go, where's the law that says I can't? And the EPA says, well, this law says, it's a problem if these substances are hazardous. And the company could come back, well, who says what's hazardous? And therefore, the existing regulation could vanish. The healthcare industry, right? The Centers for Disease Control, laws and practices for handling things like that. People talk about, concerns about wet markets like in China. Some of those questions about health and safety and the spread of disease, especially in the aftermath of the COVID pandemic, have become hot button public issues. And now almost the entirety of the regulatory system that exists to govern those things could potentially be overturned. The Labor Department, recent advances in things like overtime laws and protections, trying to guarantee that salaries can't be set in such a way that companies can get out of paying workers the overtime that they deserve. Many of those laws and regulations are now potentially reversible under a legal environment that does not include Chevron. So thousands and thousands of different cases that were established, and thousands of different rules are now potentially overturnable. And this also impacts the way that our statute law system really works, because for Congress to effectively now, under this new precedent, create laws that will help the American people or protect the American people, they're going to have to get really, really, really specific. And that's not the way most laws work. Sometimes lawmakers don't have a crystal ball. They can't see what's coming in the future. And they may not have the ability to, revisit a law every 6 months, every year, when something new comes along. And that could create a gap in which there's a problem. We know it's a problem. It's potentially problematic for the American people, but it's still going to be legal or permissible for a period of time. It also creates a situation in which gridlock in Congress, or political ideology, or who's getting campaign contributions for what industry, just all it has to do is stop changes from happening to allow for a lot of these potential risks and threats to reemerge. And some of them will likely be minor issues in terms of regulation. Some of them may be major issues, but all of them may be in the interest of, people like those fisheries that would rather not pay to have their operations monitored, or maybe a company that would rather not have to adhere to certain pollution standards, or somebody who doesn't believe that human influence has anything to do with climate change and would be happy to emit much higher degrees of smog or carbon, will challenge the rules and regulations that are currently preventing them from doing so. And our political environment might suggest that Congress won't be in a big hurry to create a new, more specific statute law that would allow for those practices to be restricted. And so this is a big change. We will see I would expect a massive number of cases that will come and will challenge much of the way our federal government works or tries to do things, on the premise and by this new precedent that there is no more deference to federal agencies as they try to interpret vague congressional laws and statutes. This is also interesting from a court watcher's perspective, because this is another major and established precedent that this court has overturned in the last couple of years. Generally, courts defer to precedent. Generally, the courts attempt to say that which has been decided previously and has been established, and it is important and governing for much of our legal system and the statutes that coincide with it. You don't go back and flip it on its head. This court's been flipping things on its head in a way that hasn't been common in the last 25, 30, 50 years. And so that brings a lot of things into question as to how this court works, what kind of things are potentially revisitable, right? And we saw one of the big examples of that when they overturned the Roe v. Wade decision. This was something that had been established law for, 50 years. And that this court said, no, we're getting rid of that precedent. Same thing with Chevron. It was 40 years, not 50, but they said, we're getting rid of this precedent. Conversely, there's also something this court is doing which we have not seen previously, and that is in place of previous legal precedent. They're advancing this idea of some kind of historical precedent that should be important to the practice of law and the observation of statutes. Specifically, this came from the New York State Rifle and Pistol Association versus Bruin decision, which suggested that modern firearm regulations need to be consistent with both the Second Amendment as well as the history and tradition of firearm laws in the United States. And that's different. That's a new idea for the court broadly, that we're not going to look at previous court precedent, but we're going to suggest that unless there is some kind of history or precedent for a law, that we're not necessarily going to consider that law to be constitutional if it's not something that was done previously. Now, critics have suggested that this is a way to kind of prevent anything new under the sun from coming into the American government. Those who are your originalists in terms of a legal doctrine kind of applaud that idea that, we shouldn't have these things. But in terms of functionality moving forward, there are some issues that didn't exist previously, right? We didn't have rules on artificial intelligence in, the 17 and 1800s in this country. So there can't be anything else there. And one of the points that's useful for us to think about is that while this does apply specifically to firearm regulations, things that set precedent do get applied in other ways. And so if there is a question about environmental regulations, would we expect this court to say something along the lines of the exercise of environmental regulation and the laws that prohibit private conduct in the pursuit of commerce should adhere to laws that are consistent with the history and tradition of commerce in the United States? We don't know. So there's a lot going on there. And this also brings up the idea of the Supreme Court itself. It has suffered a significant legitimacy crisis in recent years. And some of that is because it's doing things that some people don't like, right? If the Supreme Court's doing everything you want, there's going to be folks who are very, very happy with it. And if it's doing nothing that you want or things you actively don't like, it's reasonable to expect that there's going to be a amount of blowback about that. What we've seen recently, though, is different. And it's different in ways that we have not witnessed in the last, at least in my lifetime, and I'm 45 years old. The first is we've seen, in the case of Justice Alito, some what appear to be pretty explicit political displays. Flying an upside-down flag, flying a specific flag that's used by a Christian nationalist movement at his vacation house. It's unreasonable to think that any Supreme Court justice doesn't hold some kind of a personal political opinion, right? Everybody's entitled to it. But the issue why these public displays are so potentially problematic is that plaintiffs, defendants, citizens should be able to go to the Supreme Court to receive a ruling that is fundamentally non-ideological and based on the law of the United States. When a Supreme Court justice is openly taking a political stance and what appear to be a couple of pretty controversial political stances in terms of post January 6 insurrection support and this idea of a Christian nationalist flag, that is something that can undermine public confidence in the court more broadly. The other issue is actually with Justice Thomas and opens the door to a much bigger conversation on court ethics and bribery. And that's going to be kind of our last big topic for this video and this conversation. Justice Thomas has now, finally on record, shown that he has received significant numbers of gifts and trips and benefits from wealthy benefactors, many of whom have had business before the court. And this is problematic for a public perception because the idea, or at least amongst Thomas's critics, is that he's receiving material benefits from people who have business before the court. How can we trust that those aren't influencing his positions or his decision on these cases? Especially when, after some of these issues came to light, he refuses to recuse himself from the decisions that are in question. The same can be said for Justice Alito. That's another big legitimacy crisis for the Supreme Court. And it brings to light the odd nature of the Supreme Court as an American legal/political body. Because the Supreme Court has no legal ethical standards. It has recently created a document that it can kind of self-enforce. But there are no ethical standards or, like reasons or thresholds or guidelines for when you have to recuse yourself or when you don't. They don't exist. Similarly, they have lifetime appointments, which means that there's not a process by which, the voters or even the administration gets a chance to kind of review their record and determine whether or not they should keep operating in that role. With lifetime appointments and no ethics standards, unless they do something that would prompt their own personal resignation or create a situation in which they are impeached by Congress, they can kind of do what they want. And previously, high ethical standards and some element of legal duty, patriotism to honor your position as this justice has restrained people and prevented them from coming under serious criticism. But it looks like some elements of the political environment have changed so that some things that might have otherwise prompted a strong call for resignation or at least recusal, and if not, actively prompted some kind of impeachment proceeding, aren't in the cards. They aren't politically viable at this point. And so we have Supreme Court justices who are behaving in ways that were previously unheard of or unseen. That brings us to this idea of bribery, right? If you can go to Justice Thomas or, it could be Justice Sotomayor or Justice Kagan. This isn't an issue that has a specific political ideology. It could be any of the justices for any reason. And I can say, hey, you're a fantastic person, and I want to give you this nice, multiple $100,000 recreational vehicle. I want to fly you and your spouse around the world, and I want to pay for you to go on cruises. And I just want you to remember that, I'm in the oil industry, and that the oil industry is really important for the American economy. Don't forget that. Is that improper? How much is improper, right? What if it was instead of a $400,000 RV, what if it was a $4 million yacht? What if it was me paying for scholarships for their kids to go to high-ranking universities? Where's the line, right, in which that's potentially considered bribery? And if there's no ethical rules for the Supreme Court, could any of it be considered bribery? That's what brings us to our last part here, that is, when do we see bad behavior or corrupt behavior from public officials being triggered as illegal? And at one point in time, we had federal fraud statutes that suggested that, there were pretty strict rules on bribery. However, the Supreme Court in 2010, in the Skilling versus United States decision, kind of started disassembling some of those strong strictures on bribery in a way that actually favored the CEO of the failed Enron Corporation and took 10 years off of his sentence. Later on, in 2016, there was the Supreme Court's decision in McDonnell versus United States. Bob McDonnell was a governor in the state of Virginia. He, in his official capacity, started kind of speaking up these dietary supplements, which, he could say whatever he wants, though people thought that weird. However, it turned out he was receiving significant gifts valued at over $175,000 from those dietary supplement companies. Normally, that would be a misuse of public office, and he was convicted, effectively, of accepting bribes and misusing his public position. But that McDonnell versus U.S. decision in 2016 said, no, that's not technically illegal, and his conviction was overturned. Later on in 2020, we see it's actually getting worse in terms of what is permissible in terms of public corruption. In 2020, we saw an issue where then New Jersey Governor Chris Christie's aides planned effectively to create congestion on public roadways in order to strike back against a political rival, causing harm to the public, causing delays in order to make somebody else look bad would seemingly be corrupt behavior. But in Kelly versus U.S. in 2020, it was ruled that because nobody actually got paid, that action, those corrupt actions, were not illegal. And so no one faced any consequences for, actively causing problems for American citizens because it allowed them to kind of make a political rival look bad. In 2023, we saw a couple of big decisions come through that are problematic. And the first one was Procoro versus U.S., an aide in Governor Cuomo's office in New York State accepted a $35,000 payment to help a company get out of having to work with union workers. Union workers, they get paid more, they have higher standards, but they cost more if you're a company. And if you have to work with union workers, it cuts into your profit margins. It makes you actually follow, a specific set of rules. If you don't have to use union workers, you can pay less, you can make more profit. Well, one of these aides accepted $35,000 and helped a company get out of having to use union workers. They got an exemption. That, as it turns out, got that aide initially convicted. Procoro versus U.S. 2023 says, no, actually, that's not illegal. That conviction's overturned. Bigger still, there's one called Criminelli versus U.S. in 2023. And in that case, a contractor rigged a state procurement process, right? Contractors, they make bids to the state. They try to put forward their best bid. There's supposed to be a legal process by which those bids are evaluated fairly, and the contractor with the best bid gets the work. Well, in this case, it was somebody who came in and rigged that procurement process to get the company they wanted a $750 million contract. And it turns out that, according to the Supreme Court, 2023, that wasn't illegal to do. And all of this comes down to the most recent decision that was just rolled out in the last couple of days, and that's a case called Snyder v. United States. And this maybe is one of the most obvious and gratuitous, not that those other ones weren't obvious and gratuitous, but this is another one that's also really important because it's obvious and gratuitous. So in Snyder v. United States, there was a mayor in Indiana named James Snyder who wanted to give one specific garbage company a couple of very valuable city contracts. And they were valued at about $1.1 million to that company between the two contracts, right? So $1 million contract. In this case, James Snyder did not receive any kind of money previous to awarding those contracts. Did not receive any kind of money. Just after the contracts were given to the company cut James Snyder a check for $13,000 for consulting services. Now, in the subsequent trial, it was found that nobody could demonstrate that Mayor Snyder had, in fact, provided any kind of service whatsoever to the company, aside from getting them these contracts. in violation of actual policies, right? That's the other pit, is the policies were circumvented to give this company these contracts. And the co-owner of the company testified that the mayor came to the company offices after the two contracts were issued and demanded money. Now, this seems like it should be a pretty naked and obvious case of public corruption. However, as a result of the Snyder case, the Supreme Court has just found that the definition of bribery requires a quid pro quo, effectively meaning that you have to have some kind of stated and potentially provable in court agreement beforehand, right? So in order to qualify as bribery under this standard, it appears that I would have to be, a public official, and I would have to talk to someone, let's say it's a garbage contractor, and I would have to say to them, hey, if you would like for me to give you these two contracts in a way that breaks the law, but makes you a bunch of money, I'm going to need you to give me $13,000 beforehand. And then the contractor, or the company would have to go, okay, I'm going to give you this $13,000 now. Give me the contracts. At which point in time, I receive the money and go, okay, I have now received the money. I will now give you these contracts illegally. That would be considered bribery, and really kind of only that. Right? If I go, hey, you know what? You seem like a fine, upstanding company, and these policies seem very, very problematic. I am certain that you would be grateful, wink, wink, for these contracts to fall your way. I'm going to reach in here and kind of, push these buttons and make sure you get these contracts as opposed to anybody else, or as opposed to letting them go through our normal policy. And then the company goes, why? Thank you, wise and noble mayor. I happen to have an extra $15,000 in my pocket. You seem like someone who could use that. Why don't I give it to you right now? That would technically be legal under the standard established in Snyder v. United States. And the reason I point all of this out is, as we're looking at what appear to be some serious ethical concerns on the Supreme Court regarding money moving forward, and some of the decisions were coming out of Supreme Court, in the last year, major issues of precedent being overturned, new pseudo-historical precedents being implemented, we arrive at a position where it becomes very difficult for us as legal experts or as political scientists to be able to predict what's coming next. At least not in a way that's truly objective and not kind of just doom and gloom, because it's hard to say what is going to come of these things. Right? How do we control public corruption? And just like in the previous cases, if you are going to see laws passed that would prohibit this element of corruption, or otherwise further detail where and how government agencies are authorized to implement policies that are designed to protect us, you would need statute law. You would need Congress to act. You would need enough bipartisan agreement in both houses of Congress for there to be some kind of a law made that says, okay, we're not going to allow people to give massive amounts of money to the Supreme Court or give massive amounts of money to public officials, because that's potentially problematic for the public good and for public service. While they themselves are public servants who could very strongly benefit from these things, and for whom favoritism from either industries or unions or whatever could create a situation in which they aren't interested in passing these kind of laws or restrictions. There's reasonably a personal interest, a conflict of interest amongst legislators who like money, and kind of who doesn't, right? In not creating something that changes this, because under these rules, they could become very, very wealthy very, very quickly, and do so in a way that's technically illegal, even if that massively damages our ability to enact laws or policies that are in the public interest and vital for the safety of the people. That's problematic. And so That's why I wanted to take a minute and kind of break this stuff down, because a lot of this is very nuanced and it's hard to follow. And with everything else that's going on politically, or the desire of many people to just ignore politics altogether and watch a cat video, or this is the type of thing that can fly under the radar, right? That people cannot see or not understand happened. And then by the time we do kind of have an idea that it's happening, it's because suddenly you go to buy a something at the supermarket and it's contains food poisoning, or your source of food and drugs happen, or suddenly your neighborhood is polluted, right? And it turns out that's completely legal now. So again, lots of different things are changing here. Lots of things could happen as a result of this. I mean, has everything been undone today? No. But we've already heard a lot of scuttlebutt about people who are getting ready to file new suits under this new Raimondo precedent, and upset a whole bunch of ways in which the government currently operates. So be aware that that's a thing. Think about how it might affect things that you care about, or maybe it's something that you would support in terms of reducing the total amount of power the government has, or trying to reduce the size of the bureaucratic state. Maybe that's your jam and that's what you like. But it is worth taking a few minutes to watch this video and think about, because big changes in store for the way that the American government works. Big questions about the people who will be making those changes, because of course, the people who make the laws and the people who would be deciding these issues, instead of being experts within federal agencies with a great deal of training on this, they would be judges in courts, sometimes who are politically appointed or otherwise strongly politically affiliated, or the public officials who we've just established can feasibly take a whole bunch of money to decide one way or another, as long as they don't do it before they decide. So things to think about. Thank you for your kind attention. May you remain healthy and wise, and we will see you next time.